everybody, but we really appreciate y'all's time.
Yes,
I think we can all empathize that this is not easy to be here again doing this, especially after so long.
For everything, yeah.
One favor I will ask, regardless of who asked the question, do you guys mind looking like straight ahead whenever you answer? It'll just.
I shouldn't go cross-eyed like.
It's a lot.
Yeah, I'll here. Sorry. And I will make this easy for you.
So humid today.
It's always like this in Corpus, I guess. I'm waiting on my brother.
Did you say are they coming this way?
Yeah.
What we'll have you guys do is that we'll be all four of y'all. We'll have you just kind of in the middle of all the mics, just kind of stand together if that's okay with everybody. Yes.
Do you prefer them two in the middle and the wives on the side, or because whichever?
Up to y'all, however you want to do it. Yeah.
Yeah, let's do it so that you guys are locked in. Let's next step. Yeah.
Because you guys, now you guys can be clear, since you guys are going to be
Either way.
like that, and then Manuel on this side or something, and Julie on the other side. Thank you. Not sure if you have this problem,
That's
but it'll be
funny.
okay.
I just don't mess with the gear because I don't want to break. Okay.
So y'all are gonna like ask questions, or we're gonna say something, or
Yeah, we'll ask the questions
Okay.
and stuff, and everybody will call
Maybe.
around. I know we're just waiting for
my brother?
your
Yeah,
brother.
he's coming.
A little humid.
I don't know
Maybe we're
about
in a
that.
hurry, but
Well, yesterday was like,
Oh yeah. Well, at least there's some clouds out there.
that one big one right there.
It's one.
Yeah,
What
I know.
time is it right now anyway? 1:03.
Oh yeah.
Because we have to see
Sorry.
it.
Oh, the camera's not
But-
rolling. I need.
My sister said she saw me from a distance, but I don't know where. She said towards this way. I have no idea. Oh yes, you did. Yeah, Jesse did already. And you have on your shirt. Or lower. Oh, there you go. A little feather from a baby girl. Wow. Crazy. They stay when the little feathers are around you, Jesse.
Oh yeah. We had to go.
No, you're good. No, you're good.
Where's he at?
we've also been deciding who's going upstairs for media.
Oh, okay.
Oh,
Figuring out when we're going to get wrangled.
Are they coming?
Nobody has water in the car.
I actually do have water.
No, but
Check
you
my
don't
car.
walk anywhere. Yeah,
you're
if it was like right here, we don't need to walk anywhere. I'll be fine. I just saw him walking.
Sorry, it's a big parking lot. So.
I saw that.
They're not very punctual.
No, you're good. You're good. I know you said they had parked. It was just a matter of figuring
They
out where.
said, yeah, they saw us walking.
Oh, someone's falling now. This is why they don't let me touch the gear.
They said they saw us walking.
This is crazy.
Tell me about it.
I don't like it.
It's
like a baby iPad. It's ginormous. It folds. It's Android, so he doesn't hook up to
Is that his
any
truck
of our
right there?
stuff.
Yeah.
It's, yeah.
Just park in the street, man.
I don't like them at all. We're all like, it's heavy.
And everybody has those?
Yes, all the recorders have these now.
They just gave me an iPhone 14 and I felt special. This is crazy.
This,
You guys got
um,
phones?
It's so fascinating. It's like,
look, feel it. It's heavy. I hate,
really?
like, it's a lot.
My goodness.
Yeah.
It's like, can I just keep
Now the sun's gonna
So
come
they
out.
took
Now the
everything
sun
off our
has
app,
to
like
come
our
out.
Apples and put it on an Android, and I'm like, I'm still working on
Sorry, it makes
Apple
you crazy.
laptops.
Yeah.
Thanks, guys.
Good one.
Nice. Yeah.
are they looking for a parking spot?
Yeah, but you could have parked right here.
They're like, oh, we have to 1:30. That's what they're probably thinking.
But yeah, we got to be in
We
there.
have to wait. We have to go get.
Otherwise, they won't let us in. It'd be a pro.
That was in the bridge thing.
Unbalanced.
Yeah.
I'll rest my knee for a bit.
Yeah, you're gonna. Otherwise, you're gonna get the
grass stain.
stain on there.
I'm fine. These are like half work like pants, half like athletic pants. It's nice, but man, my back feels unbalanced like that. So
For Christmas, and my sister and I got the same like black ones, and mine are like
Totally
ripped
wrecked.
up. She was like, "What did you do?" And I was like, "Just
Life work.
Not as good as your suit is.
Like right in our room, probably not.
Christmas gift?
You
can.
No, it's maybe
Adam can
we can put it.
Really?
Yeah.
about what?
It's Susan.
Oh, your shoe looked really good. Yeah,
Oh, sorry.
I made one comment on it, but yes, I couldn't stop talking about it.
Oh.
Something along the lines of those pinstripes are nice. It must be nice to have a wardrobe budget.
Let's go with that.
The unbalanced.
I did so. As long as that's fine. Brother. That's fine. You can leave it. Yeah. It's a curse. You're gonna have to crack it.
I got here and they were like,
Hey, Juanita, can I ask you a favor? Sure. Could you kind of see if I could give us like a count to 5 real fast? I just want to see if
From a
the mic's all
distance,
picked
just
up.
like that.
Yeah, that's perfect.
1, 2, 3, 4, 5.
Okay, cool. I just want to make sure because we got so many mics balanced. And I see they have arrived. So we will go ahead and. And we'll have you guys just kind of all 4. You can come to where the microphones are.
oh, you okay?
Careful.
Almost died.
Both phones.
Get a little bit closer.
You're closer?
Yeah, you guys. I know it feels odd, but it has to. It'll pick up.
Oh, okay.
Yeah.
Yeah.
I'm just.
Already.
What? And don't feel like you
Okay,
guys
I
gotta
wanna-
lean into it. It'll pick up the voices as far as we know just fine, but of course anybody will let you know if for some reason they don't hear you, okay?
Hold on. So we're gonna.
Hi, how are you? Good to see you.
Okay, take one step more forward for me, please. Thank you.
Knock your phone down.
All right. Okay, perfect. I know you guys just got here. I'm gonna stay in the middle whenever somebody asks a question. If you don't mind just looking straight ahead, that should work best.
That way?
For you. Yes. You'll
Towards
look
her.
me, okay? Even if I don't ask.
Towards
Just
you.
look at her.
Look at you.
Don't look
Like
at the
the
camera.
stoplight.
Okay.
Okay. Everyone is good? Yes? Cool. We want to get you up at 1:30. If you don't mind real fast for us, thank you guys so much for your time. We're going to have you start by saying and spelling your first and last name and just your relationship to Jackie.
Go, Manny.
Manuel Rizzo, Manuelrizo. Jackie is my niece and goddaughter.
Julissa Rizzo, Julissarizo. I am Jackie's aunt and godmother.
Jesse Rizzo, Jesserizo, Uncle to Jackie Casares.
Juanita Casares Rizzo, Juanita Casares Rizo. I am the aunt of Jackie Casares.
Just your thoughts going. Just your thoughts going into this 1:30 session with the judge, the prosecution, and the defense. Obviously, things took a turn in the last hour yesterday.
Anxiety, lots of anxiety, hoping for the best. You know, I know that it's a hurdle. I know that it's concerning, but we've been through a long journey, a really long journey, and we hope to see it to the end. And so, something like this may be a minor setback, but we'll follow through with it.
I would say very upset. We shouldn't be standing here. Jackie should be here today. She should be turning 13 years old. There's no reason why we should be standing here. I will say this, if there's an ounce of she could have made it, she could have been here with us, they should have gone through. Again, I'm just saying we shouldn't be standing here. And if there's, again, a speck of accountability that should be, what's the word I'm looking for? I don't even know. But that's why we're standing here. Because he or they should be held accountable. We want justice, not just for Jackie, but for all 18 children and 2 teachers.
Has there been any new information that you're learning from yesterday and since Monday that you didn't know before?
Yes, but I don't know if we should share that, or we can share that right now.
Is there an element about feeling failed again if this does end up the worst case scenario?
Right. Well, we're very disappointed in the DA. I think that they had, since July of 2024, at that, maybe even longer, 3+ years, to get their act together, to work with the witnesses, you know, to get them to where we're at today and just learning what we learned yesterday. It caught us again by surprise, you know, and I mean, if there was the one word that I could say about their team is incompetent.
100%.
It's hard to remain positive, it really is, you know, and here we are, like my brother said, you know, we have a lot of anxiety, we're concerned, but we can't give up. We're hoping for the best, you know, we're here for our family, Gloria and Jacinto.
How are you guys doing? Because this is like, it's constant. It's constant, and here we are again.
You know, for me personally, I hear the defense attorney, Adrian Gonzales' lawyer, talk about the monster. We all know who the monster was. There's no disputing that the monster was the shooter, right? There's absolutely no dispute in that fact, but there's also another monster. That monster was Mr. Adrian Gonzales. Mr. Adrian Gonzales had every opportunity to go in and do something.
Exactly.
But what did he do? The lack of inaction. That's a monster action there. It created something that evolved into a mushroom. And here we are today. As my brother said right now, you know, we traveled the journey. We did what we had to do, and we asked for this. And at the end, we go in there and we hear that on a technicality, something may be thrown out, or, you know, the testimonial may be thrown out. That to me is injustice. That to me, you should have been better prepared for that. You should have prepared your witnesses for that. You know, and it is hard to stay positive, and you know, but we have hope. Seeing the parents yesterday in the courtroom, from my perspective, when you see all the moms, parents, immediate family members, and grandparents sitting there, you know, they have a glimpse of hope, and that hope is accountability. That hope is that the team, the district attorney's team, does a good job at presenting the case and laying out the case for a conviction. But when you see a hiccup, and that's putting it very mildly, to be honest with you, you know, a hiccup. But when you see that, God, it's so disappointing. And you see the body language, you see the confusion, you hear the questions, people asking you, so what now? What's going to happen now? We're not attorneys. We follow a little bit, and all we try to comprehend these things, right? But at the end of the day, you know, is it a letdown? Absolute letdown. But we don't lose faith. We don't lose hope. Just like those kids didn't lose hope that day, and they wanted to live. Those survivors that don't lose hope every morning when they get up in the morning and they shower up and they go to school, they had hope on May 24th, and they continue to have hope. The parents that have hope for justice, they continue to come here to have hope. So it's a major setback. But this setback, it's not gonna deter us from accountability and justice.
Hey, Jesse and family, when you hear the defense make the argument that Adrian Gonzales did the best he could with the knowledge he had at the time, what do you make of that argument and the defense's rationalization of his conduct?
Well, first of all, he received active shooter protocol 1 month before the tragedy. There's no excuse for that. You know, they mentioned in the initial statement, the opening statement, that he did his job, that he was communicating. Have they told us who he was communicating with? Apparently 3 other officers showed up at a different point of the building, but was he communicating with them? What was he doing? That's what we want to learn. We want the facts. That's what we really want. You know, and so, but we have to get going. But I will say one last thing is that about 4 days ago, our family received communication from the DA and told us not to speak to the media. Very disappointed in that, and here's the reason why. Because yesterday the defense team was meeting with you all, right? Mm-hmm. Did they say anything to you all? The
Prosecutor.
The prosecutor? Nothing, right? I mean, this is just disappointing. You know, they failed us in Uvalde, and here we are again.
And they want us to keep quiet.
They want us to keep
Impossible.
Lydia?
Be very minimum.
De lo que acaba de decir, cómo se sienten, y también recordarle a la gente que ustedes lo que están tratando de hacer es prevenir que esto no le vuelva a suceder a nadie más.
Es exacto. You know, es un ejemplo para la comunidad, para los policías, que si no tienen el valor de no entrar al sacrificio de su vida, que simplemente no sean policías, que se dejen su pistola, dejen ahí todo. Porque este señor nos dejó un pesar demasiado fuerte. Entonces, un ejemplo, llevarlo a corte el señor es un ejemplo para el resto de la comunidad.
¿Y sus sentimientos en contra de la fiscalía?
Decepcionado, totalmente decepcionado. Pero hay que seguir adelante. Esperemos ahora a las 4 o 5 de la tarde, ya nos damos cuenta a dónde vamos ahora.
Gracias.
Muchas gracias.
Thank you.
Thank you.
Okay. Which one?
handing you Defendant's Exhibit A. I did not file it because with the filing system, and it is our defense strategy, that's what you asked for. I would just ask, I know
It'll
you'll
be
have to
sealed.
file it, but you ask that it be sealed after you.
Yeah, it'll be sealed.
Thank you.
And you had your notes, Ms. Mitchell?
The record reflect that I'm tendering to the court my notes, all of my notes. Tendering to the court my notes on witness Aaron Robin and Maria Chavez, who are also teachers that would be located on the south end of the building.
Okay, these also were tendered to me in camera, so they'll be sealed as well after I review them.
I just wanted to also clarify for the record, Your Honor. So yesterday when I testified, after I testified, I, off the record, told opposing counsel, and I want to put this on the record, that I had not reviewed Stephanie Hale's interview with the Rangers at the time that she appeared for trial preparation. I went back to my notes. We interviewed her on December the 10th. At that time, I had not reviewed her testimony to the Rangers. It wasn't until the week of Christmas, I think all around December 26th, is when I started pulling the witness interviews with the Rangers that I reviewed her actual testimony to the Rangers. So the position that I should have had an epiphany on December the 10th when we interviewed her in anticipation of trial is misplaced, and I just wanted to make sure that that was on the record to clarify.
Yes, Your Honor, and our position on that would have been the epiphany should have occurred on the 26th when she reviewed it.
Okay. Okay, well, I'm going to review these documents that have been tendered to me in camera, but I will obviously at this point take any motions or arguments as far as remedies or proceedings in this matter. So, defense?
Yes, Your Honor. So, as the court will see from what's been tendered as far as our defensive strategy, this situation did have a significant effect on the strategy from voir dire all the way through, and through future witnesses, should they be called. We're in a position where we know under the law that we have to ask the court for a mistrial to preserve the record. However, if the court was not inclined to grant a mistrial, we do have other remedies we'd like to discuss.
Well, let me just say this. Under Heath, the greatly awaited case from the Court of Criminal Appeals about the court's discretion and power to basically, if there is a Brady violation or a Morton violation, to have the ability to exclude that testimony. And they clarified that the prosecutors, it does not have to be an intentional act. And I'll say for the record that I find, based upon what we heard yesterday, that this was not an intentional act. At best, it was a negligent act, or at worst. So I do have the remedies under Heath available, but, if you're making your motion for mistrial, I will tell you I don't believe what I've heard so far without reading although I have summarized what you gave me, and I kind of already had an idea of what it was. So I guess my question is, since we talked about yesterday, the three things that were complained about was the puffing, her seeing the dirt being puffed up. Number two, identifying or saying that she saw the individual for the first time, and the location. All right, my question is on the location issue that she testified to yesterday, and frankly, I think that was kind of a very quick testimony. I'm not sure that it resonated with the jury, but my question is there going to be other witnesses that put that individual in the same location that are going to be called later by the state?
Your Honor, I would say the most probably compelling testimony are the casings in the case that would either corroborate or override what she said. I believe the location that she placed, she's from probably in the neighborhood of 100 yards away, looking toward the south end of the building, and she puts, I believe she marked in a general area south of the building, the casings are going to be closer toward the west side of the building. That is, they're going to be further west by as much as 10 yards. I haven't figured the exact date. So a witness from 100 yards away, placing a witness within a 10-yard distance, that would be the distinction. The other potential witness, Noni Flores, testified that, would testify that the gunman, as she saw the children go into the south door, she saw the gunman at the south and west corner of the building, which I believe her testimony will put it halfway between where the casings were and where this witness says it was.
Okay. Well, I did a little research last evening, and again, I don't want to. I've reviewed your in-camera explanation of how this affects your defense strategy, and I'd already kind of gleaned what it was. So I can tell you, I'm going to deny the motion for mistrial. You have made it, and you've preserved your record. Again.
Yes, Your Honor. In addition, can I just, so I can make sure it's clear, because we all know how the courts start interpreting it later. We will go with whatever remedy the court decides that we can decide it. However, we do not believe that it's a sufficient remedy, and mistrial would be the only.
Yeah, again, I'm going to deny the motion for mistrial over your objection, obviously. And I'm going to find under Heath, although it's not a prerequisite, that it was not intentional by the district attorney's office. It was negligent, and I don't believe what was testified to in front of the jury resonated enough to significantly affect your trial strategy. But what I am going to do under Heath is I'm going to exclude her testimony.
We have just before you do that, really, I just want to know we have a response to if you would consider that. So.
We would also have a response to that, and just so we can explain to the court that our primary concern with an exclusion is that basically what's happened, and I understand the jury, and you'll instruct the jury to disregard. I think a lot of that testimony, though, is going to be difficult for them to disregard. A lot of it is emotional testimony. One of the things that we were thinking about as a remedy would be to allow us to play her statement to the Rangers in its entirety to the jury so that they can hear what she said in the first 4 days.
Well, I was going to give the option of, even if I exclude her testimony, you still, if you wish, could cross-examine her and do that.
Okay.
And then at the conclusion of that, my thought could be to exclude it at that time.
Yes, Your Honor. It's not, because I guess my concern would be if we excluded it now and they haven't had an opportunity for it.
I was going to give you that choice, but you jumped ahead of me.
Sorry, Judge. I'm sorry. I got a little afraid. I'm sorry.
All right, Ms. Mitchell, what do you have?
Your Honor, we just have a state's response to the defendant's motion to exclude the testimony of witnesses SH in anticipation of their motion. So I just want to file that with the court for the court's consideration. If you could file stamp this copy too.
Okay, well,
And that's my copy.
Good.
The first copy's for the judge. I'm sorry.
okay, thank you.
I just want to file a stamp copy.
Okay, so again, this is kind of a sua sponte remedy that I've devised. It's not really their motion. Did you file a written? Did you file something?
No.
Okay.
This is just anticipation of an oral motion to exclude, Your Honor.
Okay.
I don't know, Your Honor, can we confer as to possible remedies and see if we can come up with a solution? Would the court be open to that?
I mean, if y'all agree on a remedy, I'm happy to entertain that, but I want the record to reflect that pursuant to Heath, I do have, discretion to craft a remedy any way I see fit. But what I've already done, for the record, is we have given a continuance to the defense until tomorrow, and we're having a hearing outside the presence of the jury to entertain potential remedies and make findings of fact if necessary. But for the record, there was a motion for mistrial, and on that motion for mistrial, I'm going to find it's denied because I think the remedies available are sufficient to protect the due process rights of the defendant. And if y'all want to agree on a remedy, I'm happy to entertain that, but I have one in mind, and I'm going to give the defense some leeway on how they want to proceed with the witness in front of the jury in the event she's recalled after we talk. So take 15 minutes, y'all talk, and we'll come back into court, and I'll review the state's response to the oral motion and finish the other in-camera matters that were submitted to me. But is there a place, well, if you want to just go back to my office, I'll stay here and you can go back to the office that they've provided me.
We have a room actually that they've given us over here that's...
Or you can go, actually you can go to the jury room if you want to, because nobody's there. But I'm assuming that contemplates conferring that everybody goes. The state joins you. Okay. That's fine. All right. Well, y'all let me know. We'll be in recess till you come back. as we speak. You're welcome to verify the clerk is sealing those documents as we speak.
Thank you.
The,
Okay, she's ready to go. So once again, we're outside the presence of the jury, and I've given counsel an opportunity to confer on potential remedies in regard to the witness. So what do y'all have to report?
Judge, we've had pretty productive talks, and I believe, and correct me if I'm wrong on any of this, that the proposition at this point, with them still reserving the right to think of it overnight and start in the morning, is that they continue their cross-examination. They get to also play the entire statement that she made. We would then get to redirect, and then they still reserve the right to ask you to exclude all the testimony. And
Yeah.
that part we feel comfortable.
Yes, Judge, and under the idea that we want to unring the bell first before there's an instruction to exclude it, because and have them exclude it all in its entirety, which is fine. But we would like to be able to unring that bell and then make that decision. Depending on how that cross-examination goes, we might not ask to exclude her, because there are some things that she says that we're just trying to evaluate her testimony after it is to see, on balance, is it more beneficial to our case or is it not? Like, after we've unrang the bell. But if we determine on balance that it's less beneficial, we would still like to have the Heath remedy for the late disclosure.
Well, for the record, I'm offering it right now. I'm offering the Heath remedy to exclude her testimony immediately. But if y'all want an opportunity to try this, if both sides agree, I'm happy to implement that agreement.
Yes, Your Honor. What we believe is ultimately we believe we're asking the court to exclude. The only issue is that we just want to be able to unring the bell first.
All right.
Is the idea.
And I know I told her, but she knows she's supposed to be here at 9 o'clock tomorrow. Okay.
Yes, Your Honor. Additionally, I will say that that in light of it, whatever harm that the court has determined in the defense case strategy, or in emotional impact, we would add that, and we do believe that under our 403 motion and motion in limine under the autopsy photos and the like, that it would start to, that the court should add that in the 403 balance. Because part of what was not disclosed is something that is, I guess, on an emotional level, especially in what this witness testified to has a tendency to prejudice the defendant. She was taking shots. She was actually personally traumatized by these things that we are going to show that she has never said before. But the jury, having heard that, we believe that it should be a part of the 403 balance when the court eventually, I know you haven't made your final decision about what it is, but I would just, for the record, I would say that it can compound the harm if there's a disclosure, and then the probative value, whatever that is, of them trying to get into these photos of these children, are the prejudicial danger is compounded by something like this occurring in the trial, as to how it can affect the jury. And so I just wanted to put on the record now, I know the court hadn't made the decision, but just to put that in the court's mind that we are also going to be arguing that at a later date.
All right.
And Judge, I just wanted to be clear, because I originally heard the court say, I'm willing to strike all the testimony now, but I'm also willing to entertain the defense's claims.
I want it on the record, because I've denied the mistrial, that in lieu of the mistrial, I'm ready to exclude the testimony now. But if you all want to agree on this, then I will implement your agreement.
Could you give me 1 minute then? I'll be through.
Yeah, and I guess yes. I think just the court understanding, willing to strike now would the only reason we're not accepting that. What I don't want to do is be in a situation where I'm on the record saying that I don't want that court's remedy, because then the courts later will say, well, then if you didn't want the court's remedy, then how can you claim that the mistrial was wrongfully denied, right? So what I want to do is just say that the reason we don't believe that striking it now and like she just goes away is that we'll never have an opportunity to unring the bell.
And we think that the court's remedy of striking it all now is sufficient.
Right. You see what I mean? And so, and so what it does is it puts us in a situation where that remedy could actually harm our client worse. By.
Well, all right. Well, we'll let the defense proceed as we just discussed, and she needs to be here at 9 o'clock in the morning, and then I'll make a decision on exclusion with everybody's participation after we rest and or actually she's finished with redirect and recross, whatever the case may be.
Yes, Your Honor.
But my recollection is she's on cross now.
She is.
Okay.
We left off where I was refreshing her with her statement, and then that's when this issue came up, and so I would just continue with the cross-examination.
They've passed her and she's on cross.
Yes, Your
now.
Honor.
Okay. All right. Very good. All right. So 9 o'clock tomorrow with the witness, and we will proceed at that time. Thank you very much. We'll be in recess.